request otherwise. Having said that, I want to invite the Prime Minister to open this debate. You're here.
Okay, thank you, everyone. Before I begin with my constructive, in which I will tell you how we need to give people who are guilty the opportunity to be absolved of all the guilt, and secondly, how we shouldn't force the jury to declare someone innocent when they think they're actually guilty. Let me tell you a bit in which scenarios that this happen. So this thing happens in institutions where they have this barbaric institution of a jury, and the jury decides who is guilty and isn't guilty. And they usually decide for the decision not proven, for the verdict, in situations where they themselves believe that the individual is guilty, but they cannot make them guilty because of certain either process errors, either because some evidence was removed after it was presented to the court, but it's all related to what was happening in the court. We don't think that this decision can be completely arbitrary, right? There's still certain criteria that has to be met, but the criteria is lower than for a verdict of guilty or not guilty, right? So perhaps it's not proven that a person, it's beyond reasonable doubt that a person has done something, but a juror might believe with full conscience that something that a criminal action has been committed on the basis of the evidence that was at some point presented but later discarded. So why we believe that it is important that we have these institutions is primarily, and this is the first argument, that currently we have a very big issue that everyone who is being pronounced, declared to be non-guilty, is put to the same basket, those who are really non-guilty and those who the public and the jury might believe that they're guilty, but they have to be declared non-guilty for the purpose of the process. Before I move into the explanation, I take Ron for the clarification.
Does anything happen to these people beyond the declaration that that the case is not proven? Are you going to impose any sort of further legal ramifications to that individual?
No, nothing. Nothing happens. So the legal ramifications, as per the info slide, are the same as if you were declared not guilty. Only one different thing is that those individuals can, of course, still appeal to that decision because, I mean, they were declared that not proven, but they might believe that it's proven they're guilty. You can technically also apply I don't think it's even possible to appeal to a decision that you were non-guilty. Okay, now moving on to the constructive. Why is this situation very important for the people who have been declared non-guilty, so innocent, but on the basis of some kind of a process error or lack of evidence? And like here, a bit of framing. Firstly, that usually, I mean, the court is very clear in explaining the decision, right? And already it can be from the decision of the jurors, or in situations where the judge itself read the decision, it can be seen like what's the exact opinion of the court, right? So to what degree did in fact that person commit a certain action, and to what degree were the evidence respected, and to what degree are they acquitting them on the basis of lack of evidence or an insufficient presentation of evidence, right? So I mean, the message they're sending to the world is very much different in situations. So even if the decision is the same, like not in our system, so in the other, like non-guilty for those who are in fact guilty but not enough evidence or not correct evidence, and not guilty for sure. I mean, the decision is the same, but it's presented in a different manner, right? I mean, when someone is acquitted for the lack of evidence. So this means that individuals who are found non-guilty, but they were declared so because there was some kind of a trial error in trial or something like that happened. This means that they're never really fully acquitted, right, in the eyes of the public, in the eyes of people around them, right? Because I mean, they were found innocent on the basis of some kind of error or some lack of evidence, and even some jurors might say later at some point or in public or through little hints or stuff that can happen, that they believe that individual was not guilty, and this has huge repercussions for the individuals, those who are found non guilty, for their life, right? I mean, not only stuff when it comes to employment, like it's more difficult to get it. If you're a public person, you literally all your doors are closed, right? And how you like communicate with the others, that when you meet someone new, when they found out that there was a crime, that perhaps the jury and the judge think that you did it, but still they acquitted you because of kind of a process error. I mean, this has huge significance on the individual's rights. In comparative, if you have the option, right, that you differentiate, right, so that someone who is like really proven that they haven't done anything wrong and that the evidence is clear, they are non-guilty. It's clear, everyone knows it, right? But if you have the decision, to that for someone that you don't know, you can say that it's not proven, then it's a clear differentiation. Not everyone is put into the same basket, and this does lead to positive impacts. CEO.
So you're going to let them off, and they might not have a retrial. If a jury thinks someone's guilty, why shouldn't it just be a mistrial and then we have another trial?
I mean, mistrial is different, right? And it says so in the info slide. I mean, if something wrong has happened, a retrial might happen. This is not the case. Like this situation applies when the trial was in accordance with everything okay, but certain stuff when it comes to evidence wasn't presented in the same way, and that. So that's irrelevant from CO. But like we are accepting the trade-off that is happening in this debate, right? We do acknowledge that certain individuals are going to be worse off, those who are truly innocent, but now they're going to be declared that it's not proven, right? It can possibly happen the other way around. But here, I mean, we are willing to accept the trade-off because these individuals still have certain ways, you know, they can improve their situation. They can still appeal to that decision, which is like highly, you know, and they're highly encouraged to do so. Like why? Because they can prove then with later actions that in fact they're not guilty. And if themselves they are not guilty, they haven't committed the actions, there's no possible way that they will be proven no they're guilty and they will have to go to prison. And there's like every incentive for them that they will take this decision and then wash the blame from themselves. And I think that this is also highly likely to happen. Of course, it does not you know, incur additional costs to them because they're applying to the appealing against the decision that was done wrong by the court, and therefore the costs will be returned to them. Yeah, they will pay for the lawyer attorney possibly in systems where they have to do so. And lastly, we think it's principally unjustified to force the jury, which in full conscience believes that individual is guilty, when it happens to declare someone non-guilty. I think like this is like principally wrong. And it creates also practical harm on the conscience because the jury is knowing that they're declaring someone who think they're guilty non-guilty. And I think like you have to live with this. You're responsible for that, right? Whereas in comparative, you say not proven. You say maybe they are guilty. That is what I believe in my full conscience, but still you're not forcing them to do so. And I think that this is better also in these aspects. Okay, thank you all.
Thank you for that speech, Prime Minister. I would now like to invite the Leader of Opposition.
One second, please.
Sure.
I'm going to start my speech in 3, 2, 1. Our case from opening opposition is straight, it's clean, it's simple. 1, this is morally wrong, and the trade-off we're making on just a value judgment should not be made in this debate. But secondly, and I think this is crucial, in terms of the practical analysis in this debate, we're talking about the cases on the margins which would otherwise have been found guilty or not guilty, but are now going to be found not guilty or not proven. We think that those specific subset of cases are illegitimate and lead to worse justice outcomes for some of the most vulnerable people in society. Before that, 3 points of clarification. So the first thing is, and I know this is a semantic quibble, in this debate, there has to be some impact of being found not proven, which is distinct from being found not guilty. Because if there wasn't, then there would be no reason that it would weigh on the jury's conscience to make the determination between the two. There would be no reason for this debate to be happening at all. We want to give you a more realistic characterization, which is that a not proven verdict would probably have 2 impacts. Firstly, a moral condemnation by society, which makes the condemnation of the unknown of not guilty, although we're not really sure what that is, pale in comparison, because a jury has actually defined you to be guilty. And that affects, if people know about it, the way that people interact with you. They essentially see you as guilty. But I think the second thing is, this has to go on your record. Like, I think it is actually quite important. So for example, there are certain procedures and checks in the UK. So for example, DBS procedures where you have to, like a certificate you have to get when you're working with kids to have your full criminal record, where it might be actually quite relevant that you are found not proven and possibly guilty or like determined to be guilty for committing that kind of child sexual offense. So I just think that on the balance of probabilities, there are going to be at least some limited harms, even if there's not an active punishment for being found not proven. Second clarification, I think that this debate, if it is about disparities in justice, does not fall on Gov for that. And the reason for this is, if we think about the people who are unlikely to be affected by this, so for example, rich people who have great lawyers, on both sides of the house, they're probably going to want to push for a mistrial and get a not guilty verdict, because they themselves recognize that a not proven verdict actually comes with quite a lot of stigma of guilt. So, you know, there's no marginal change there. Where there is marginal change is the cases I'm going to talk to you about. The final point of clarification is, even where, like, what this motion essentially does is says that for a large portion of people, they are no longer innocent. For those who are actually innocent but are found not proven, that is an active harm in the way that being found guilty is when you are innocent, but especially if like being found guilty without a custodial sentence and any like physical harm in prison. But secondly, and more importantly, it's not clear why it's more important to help the perception of individuals who are found not guilty under the status quo, given that I am unclear about the extent to which individuals are considered to still be guilty, even when they are found not to be guilty, given that we have a reasonable bar that you can't be considered to be guilty, that there is no evidence to suggest you are guilty. Okay, principle. I think that the first thing is that criminal findings and impacts, just as an intuition, are the worst flex of state power, insofar as the implications of being determined to be guilty, not proven, or guilty or whatever, are that condemnation by society. The state has a powerful signal to the rest of society for what is or isn't moral, and at the more extreme end, custodial sentences are a deprivation of your liberty and a harm of your rights. This is why, if you have any doubt, we think that we should stand by the principle that people deserve not to have any moral condemnation and not to be cast and castigated in society. And I think this is for two simple intuitive reasons. The first is that in general, free individuals prefer freedom to safety. We can trust ourselves more than a distant divorced entity like the state. This is why we make contracts with strangers, but we give money to our like mates on mates rates, because we trust ourselves and those proximate to us more than that distant entity. Nothing is more distant and abstract than the state. The second thing though is, and what the implication of this is that we make a cautious contract with the state and trade off marginally more crime with marginally more freedom in society, because any one of us could be a victim of this not proven verdict. The final thing here is, even if this is not true, for any action of harm to be just, you must be able to have an objective standard, which is why the standard is so high under the status quo, which is why a mob can't just come and kill me just because this is popular. So the final, I think the most important thing to note here, right, is that creating and condemning more innocent in favor of a not proven verdict for a few more guilty doesn't make sense. And this is for a number of reasons on the comparative. The first is that victim harm has already been done and many crimes are victimless. But also, not proven verdicts are unlikely to provide recourse to victims. They're unlikely to send a strong signal of deterrence. They're unlikely to meet the pillars of justice. But on the comparative, there is an active harm of moral condemnation and penalty and unfairness to all individuals who are proven to be not proven. Even if you think that moral condemnation is a small thing, the fact that there is not any marginal change in improvement on the justice system on their side means that on a principle it weighs out. Before I explain what the practical implications of this are likely to be, CG Shaw.
If you think the state is too powerful, then surely the jury system or an independent judiciary is there to balance that out.
Okay, thank you. Let's move on to the second point. What cases on the margins actually get followed? The first, or actually lead to not proven verdicts. The first are cases with bad evidence but strong bias of juries. So for example, when you really feel like somebody is guilty, but there is not enough evidence to say that that person was guilty. Why does this matter? Because I think evidence is important insofar as it is something that is objective. It is something that is physical and something that is real. It is bloodstained. It is actual phone conversations. It is logs. It is things which which cannot be disputed. I think the reason that you need that objective standard and people should only have any determination at the point that evidence is found is because that is the only thing which is free from bias. If we don't need evidence to determine anything, then for example, a black person being convicted or being on trial in the South is likely to get a not proven verdict where an all-white jury would have otherwise been forced to give them a not guilty verdict because there was just no evidence, so they couldn't give them a guilty verdict. But now you give them a way out because their biases see through. The second case is where there is a lack of evidence. And I think this is important because, as I said, a lack of evidence implies that it's less likely that people did a crime in the first place. The final context is one where there is police error, as opening government said, where there's poor case building. I think this is good. And I'm actually okay to trade off a few more guilty people going free because the police were dodgy. Why? One, this forces the police to up their standards, which improves the investigations for everyone. But secondly, there are different types of flaws. The police are also succumb to things like awful interrogations and basically getting statements from people under coercion. They also succumb to things like bias and that affecting how they searched out and sought their like criminals versus innocent people. So if this improves police standards and acts as a check on those people, we would prefer that because on a balance, those people are more oppressive to your life than a random arbitrary criminal. On a comparative of who is losing out, we're winning top half.
Thank the speaker for that speech. I would now like to invite the DPM. You're here.
Three points in this speech. One, the first principle that Rok brought in the PM speech is about the people who are in this system that we are supporting actually shown to be not guilty, which is now differentiated from not proven, which is a very big point that the LO has missed in their speech. What did Rok mean by that? In a lot of cases, someone is accused and put to trial for something they obviously have not committed, and the jury finds that obviously this is not something this crime is not something that can be attributed to them. But the problem in status quo is very often the society doesn't really care about legal standards or this or that. The society likes, scandal and farce, and are very often going to turn against someone in the court of public opinion, and that person is going to be unfairly stigmatized, even though they obviously have not committed a crime. We tell you that now, when you have a clear difference between having not proven and having not guilty, people who are now found not guilty are now absolved of a harm and damage to the moral character that they otherwise would be a victim of, without having the not proven claim. AKA, they can wash their hands much more efficiently. Rok brought this to you. LO never responds. It's too late for DLO to respond to this argument now. Two, not prove people. A very crucial point of what Rok characterized was that when you have not proven verdict, you can also, in our world, appeal against that not proven verdict. You can find arguments against that not proven verdict. And this goes against the overall majority of what LO had to say. Why? We tell you that public perception is always going to stigmatize. Public perception is always going to go against people put on trial. And this is even more true when we talk about racial or ethnic minorities. When a person of color is in a trial in the United States of America for a gruesome crime, even if they are innocent, the public court of opinion is going to say that they are guilty no matter what happens. And this is true for most of those marginal cases. For all the marginal cases that, LO says that are now going to be the majority of those who are going to be not proven, we tell you precisely this is the problem. People who are going to be in the marginal cases, the society is always going to think that they are guilty. Because, the society is racist, doesn't understand how law works, likes scandal, likes pointing fingers, likes gossiping, all those things. I think it's pretty safe for us to assume the worst of human nature when it comes to this. And I think you have plenty of examples about this. For instance, the example of, O.J. Simpson, right? Like, people who decided that O.J. Simpson was guilty because he was black, because he is black, and those people who decided that would think that no matter what would happen with that court trial, and this is true for so many of the so-called marginal cases. Now, why is this characterization important? Like note here that LO never says anything against this. Like LO never actually, disproves this claim, which Rok already brought to you, by the way. So too late for the LO to respond to this. This is important because now, if the jury, if the jury says not guilty, if the jury actually says not guilty, now this already helps against this stigma somewhat, as I said in the previous point, because now I can say, look, the jury could have said not proven, but they went so far that they actually said not guilty, which we think that no matter how marginal an impact it can be, like depending on how much trust the society has in the jury, but it does help somewhat. But furthermore, in the case of people who are now going to be found not proven, for those people, now at least they get the chance to appeal against the decision of being not proven. Before, in the court of public opinion, when everyone thought that they were guilty, there was nothing they could ever have done. If a black person is put on trial and they are found not guilty and they are innocent, but the public opinion is formed against them, if everyone thinks they are guilty, there is nothing they can do to wash their name. In the system that we're proposing, they can appeal against the not proven guilt, the not proven verdict, and that actually makes it easier somewhat for them to clear their name. Before I continue, CO.
Putting aside that most trials are not in the public attention, most times the public knows the biases of a society. For example, that the police pull over Black people inordinately in the United States. Don't they take that into account when deciding whether someone who's called not guilty actually did a crime?
No, this is, okay, I'm not sure what society you live in, but most societies are relatively racist. I think it's quite clear that, with all the recent trends in North America, etc., etc. But second of all, when you say most trials are not in the public eye, well, no, but see, it doesn't matter, even if they're in the eye of the neighbors, even if they are in the eye of 10 people. The thing is, that the public is going to here, this is why what you're saying is rather stupid, actually, because if no one cares about the trial, then no one is going to care about the not proven verdict, because there is no legal repercussions. Like OO cannot just say there's going to be some sort of a mark or something. Like there is no legal repercussion. So if no one cares about the trial, then there's no problem. However, if there is at least one person who cares about the trial, they're probably going to be more judgmental and more quick to make judgments than the jury, because the jury actually takes evidence into account, and is forced to be less racist and whatever than the public. And then for that, people have the chance to appeal against the not proven verdict much better. OO never responded. But then the third point that Rok brought to you, zero engagement from OO, literally zero, is that we find it principally problematic that you, as a member of a jury, are forced to go against your values and pronounce someone as not guilty when you yourself are sure that they committed a crime. We tell you already the society is forcing you to be a juror. Like in most countries, you cannot get out of being a juror, or actually you are punished if you try and doing that. And now the society is forcing you to clear someone's name because of a legal standard that they employed. We tell you this is unprincipled. We tell you this cannot stand. This is why we support the non-proven verdicts. OO never responded. We are taking this debate here.
I thank the speaker for that speech. I would now like to invite the DLO to close off the upper half debate. You're here.
Can everyone hear me? Cool.
Yep.
Oops, sorry, 1 second. Yeah, cool. 3, 2, 1. There is a dangerous inclination by those who wield power to assume that because there is a temporary, discrepancy in the way that some system works, that it is fair to strip away some of the founding principles that ensure that that system is fair and will continue to be fair and will never be, used and weaponized against citizens like to achieve some sort of extreme coercion or whatever, use your imagination. That's the like unfortunate reality with a lot of criminal justice cases. People will point to examples of, well, you know, this one case that I can think of that's really emotive didn't work because of some very obvious glitch in the legal system, and therefore use that to correct a system that thus far, by and large, protects people from the worst abuses of state power. What we tell you in opening opposition is that the reason there is a binary distinction between the two, and we do not particularly care what the actual words are, is that on one side of the semantics, which happens to be the word guilty, but note that is just the choice of a word, you are subject to some sort of repercussions by the state. On the other, you are free from the repercussions of the state because you do not meet the objective standards of proof required for you to merit that punishment in the first place. That is why it is a binary distinction, and all other instances are unfair. The exception, therefore, being mistrial, where a second trial is guaranteed in order to correct the failures of the previous trial, whether that means replacing the jury or the biased judge or acquiring evidence through some other means. Now, I got a little bit confused because across the two speeches, it seemed like at multiple times they claimed that you can or can't appeal this. I do not think that any of this particularly matters, insofar as that you should never have been branded with this verdict in the first place, because it will be used against you. Because note, per the info slide and per the way that this is reasonably likely to be used, this entails that the jury has decided that the person is guilty. From anyone, therefore, who is outside of the courtroom, that means that a panel of, I don't know, 12 or however many fucking people it is in whatever country you exist in, looked at the details and the evidence of that case and were limited only by a sort of quirk of the law or a clever argument by a lawyer or whatever it was. Nonetheless, that is the perception from the outside will be that this person is de facto guilty, and all of the harms, bar the one exception of losing their freedom, are still applied to them, and that is morally reprehensible and utterly unjustifiable. So when they say, well, there's a principal harm, and by the way, DLO is allowed to respond to OG. That's very much what the DLO speech is for. Cool. They say that there's a principal harm to the jury of declaring someone they believe to be guilty, not guilty. So my question to them is, by what basis do they believe this? Because if they saw the evidence in the trial and that evidence was sufficient under the criteria that was decided collectively by society as being a sufficient objective standard of proving that someone is in fact guilty of the crime they've been accused of and deserves to have their rights stripped away from them. And no, while that standard is labeled as beyond reasonable doubt, notice the number of people who meet that standard despite being completely innocent and then later found to be like not guilty, right? There was a appeal of the trial, right? So the consequence of this is if so many people are already falling on the wrong side of this, why do we want to set back the barrier a little bit further and ensure there's this massive additional grey pit that they can fall into, which will have almost equally ruinous ramifications for their life when juries do not have any basis to believe this? Because this is a legal verdict that they are making. It's not a universal truth. No one is forcing juries to step out of the courtroom and when someone asks them, say, you know, do you believe this person definitely didn't commit the crime? And they go, yes, I have to stand by what I said. No, fuck no, they don't have to do that. They could tell their friends and family and everyone who asks them, you know, I think probably he did it, but we didn't have the evidence to convict him. He's not guilty. CG, like in POI, flag that, you know, juries exist to provide some sort of objective standard of citizens in terms of the process of justice. But they completely miss the point if that's where they're going with this, because the nature of juries is to act as a limit on state power, not to extend the state power in instances where the mob has decided or their internal biases or the prejudice or a particularly persuasive lawyer gave an emotive speech but didn't have any fucking evidence to back it up. That's not the role of juries. It's to limit state power in instances where it is being applied unjustly. What we say in aggregate is if the law is continuously failing in such a way as that the legal protocol, the wording of a particular law allows people to escape, then that's something that should be rewritten. It's not something that should be corrected on an arbitrary and non-systematic basis that can't be reproduced. Because if you happen to be black, or if you happen to have a jury that just don't like the way your face looks, you end up walking out of that courtroom with something that marks you as being guilty, and you have to live with that knowledge that everywhere you go for the rest of your life. Why is it important? CO flag this in a POI. Most cases are outside of the public scrutiny. In those cases, people will never believe OJ said he's already de facto not proven, or Michael Jackson or whatever. But the distinction is 99% of people don't get news coverage of their cases, or maybe just small amounts of local news. Therefore, what matters to these people is exactly what's on their criminal record. So if they go and apply for a job in the future, no one in that town might know them. No one knows that the case existed. No one knows the details of that case, but they see on there that a jury of people witnessed the crime levied against this person and decided that despite the legal technicalities, they still believed them to be guilty. That can fuck up a person's life irreparably and is therefore completely unjustified. The upshot of all of this then is that you need to split across the two cases, right? Because what they tell us, but now the not guilty verdict is a definitive statement of innocence, and the not proven verdict is, that occupies the state that exists now. Okay, but if that application is asymmetric and subject to the biases of a jury, then that is morally unjustified, because it is essentially allowing a jury of people to impose their prejudice upon something without the consent of the law or of society. I want to then deal further with the legal exceptions. No, right, sorry. They say, oh, well, there are tricks that exist within the legal system that allow people to escape justice. Things like, some evidence not being applied in the correct order. Why did those exceptions exist? Things like the fruit of the poison tree, where if a piece of evidence was acquired illegally, like the police broke into your house, stole something, and then you were like, cool, now we can get a warrant. The specific reasons why that exception exists and why it is sufficient reasons to dismiss a trial is because we do not want to create a system in which there is an active incentive for the police to continuously violate the law in order to secure evidence that will allow them to conduct a trial successfully in the future. That's why we do it. It's because we accept the moral harm that exists in the status quo of letting an innocent person walk without the verdict, but to ensure this can't be replicated in the future. The problem is, and the reason why we make such egregious defenses against the worst excesses of the legal system, is because we do not want them to be weaponized in the future. So in the instances now where you know that a person is particularly, or any individual particularly, I don't know, non-photogenic or poor conducting themselves in public and likely to be seen as being particularly guilty, you now have the power to render them and to mark them guilty with almost zero evidence, because this policy allows a jury to make that verdict abject of any real concrete evidence. It's immoral to hand the standards of truth to a jury when they do not meet the objective standards that we've laid out as a society. If you want to update them, fine. There ought to be a pressure to do so. We should not be correcting the fundamental basis of how criminal justice operates simply because in a rare number of instances, it doesn't function as we believe it ought to. Proud to oppose.
Thank the speaker for that speech. That ends the upper half debate. And now for the lower half debate, may we have the member of God?
Yeah, cool. Can you please confirm that you can hear me clearly?
Yep.
Okay, excellent. In that case, I will be starting in 3, 2, 1. I hate having to spend my time on clarifications. Top half forces me to. Clarification number 1, why this isn't about things like racial bias. Well, that most of these things don't have to do with a lack of evidence insofar as they have to do with one of 3 things. 1, guilt has been established, but is being over-punished due to racial bias, i.e. you found a guy with 5 grams of marijuana and you put him in prison for 3 years. 2, pre-existing laws that force you to over-punish or irresponsibly punish, things like 3 strikes and you're out, things like broken windows policing, or 3, a biased refusal to take into account attenuating circumstances, like the fact that someone has committed a robbery or someone has dealt drugs, but the reason why they have done this is for economic reasons because they had no other recourse. These are the vast majority of cases where you have things like racial bias in, for example, the United States. They don't have to do with lack of evidence. Clarification number 2, incorrectly collected evidence in response to LO gets dismissed in court on both sides of the house. Notably, police KPIs are presumably determined on how much people they put in jail because that's how they get incapacitation and rehabilitation. Given that disputing incorrectly gathered evidence is literally the easiest way for a defense lawyer to dispute a verdict, the police has incentive on both sides of the house to not do that. Clarification number 3, closing opposition's alternative of mistrials is useless because the amount of evidence doesn't change with the passage of time. If anything, it decreases where you need things like biological evidence like DNA and fingerprints. So that's uncomparative. Clarification number 4, which crimes is this about? These are things like, for example, sexual assault, where there's circumstantial evidence, no witnesses or few evidence, or the crime is reported late because the victim fears they're not going to be believed. Things like domestic abuse, where there are very few defense witnesses because people do not side with the victim or don't believe the victim. Things like workplace harassment, mobbing, and discrimination. 2 important characteristics of these crimes. 1, evidence does exist in the status quo. This is not an evidence-less crime. The problem is that beyond reasonable doubt is a huge burden, and the evidence tends to be circumstantial. The second important characteristic is that these are cases where there is an a priori bias towards the victim, both within the institution, but within the general power asymmetry, such as the patriarchy, which has hurt them, which means that a priori there exists an inequity of arms towards that victim, which means that perpetrators very often get away with the crimes rather than not. You can just look at the statistics of how many people who are convicted of rape get away as opposed to how many get convicted. This is where we get impacts on our side of the house, and impacts are many. One, on deterrence. Know that things like sexual assault and domestic abuse are very often premeditated crimes. You will stalk someone in a dark alley. You will make sure there is no CCTV. Once you have committed your heinous act, what you will tell them is no one will believe you. You will base your claim on the idea that nobody has seen this crime and you know that you're going to get a not guilty verdict. At the point where you can be found not proven, particularly in the wake of movements like Me Too, a huge amount of awareness that these things are happening, but just very often on a witnesses level, where immense amounts of people, including the civilians who are in juries, have empathized, there's a far greater likelihood that you get not proven verdicts, which means that now there exists some deterrent. Opening opposition in LO says, there is no deterrent. Opening opposition, the remaining 13 minutes of their speech, it's horrible that these people get branded as victims. This influences their social interactions. This influences their employment. They bear a mark on themselves. Thanks, opening opposition, for proving that this indeed is a deterrent. And insofar as people who take advantage of the fact that they're going to be branded not guilty are individuals taking into account the power asymmetries towards their defenseless victims, we're very fine with that being a deterrent because it works against perpetrators, not against victims. Secondly, we do indeed believe that this brings closure to victims because we do not want victims to go through an entire ordeal of a criminal trial just to not be believed. We believe that opening opposition is completely correct to say the harm of the crime has already been done, and this is irreversible. This indeed is why the reason you go to court is one, to vindicate your claim that you indeed are a victim, to get rid of the internalized guilt, to get rid of the doubt of whether it was maybe you because it's the patriarchy or internalized misogyny that tells you it was your fault, for someone else to tell you that they do believe you and that you're indeed hurt, but also for the people surrounding you, your family, your community, the individuals you have to live with every day and see every day, also for you to be able to say that someone has confirmed your claims. Now you get to say the state, the court, which has a veneer of legitimacy, which is based on the Constitution and the flag, which you hold sacrosanct, has objectively said that they believe my claims, which not only means that the people you interact with are more likely to believe you, but it also means that on a personal level, you are vindicated. You get the closure of being able to say, I was indeed a victim. And when I spoke out, I was trusted. And now I know that it was not my fault, but the fault of the other person. And this is how you regain control of the recovery from trauma and how you are able to move on. Thirdly, we say we give more leverage to victims within court procedures. Firstly, in terms of out-of-court settlements, right? Because many victims of domestic abuse, of workplace harassment, may want to be fairly compensated for the crime that was done. The harm is irreversible, but they can at least get a quid pro quo. Now, within negotiations, their lawyers are able to leverage the harms of a not proven verdict, to legally prove the likelihood of a not proven verdict, and to show that they're not going to be able to get away, which means you're more likely to get such settlements. If you don't want such a settlement, you're more likely to actually be able to get your day in court. But secondly, we're more likely to get equity of arms on our side of the house. And this is where the rich people point comes in and opening up talks about. What the rich most usually do is they get the most expensive and best lawyers in the world who expose technical flaws within the legal process, who pay a private laboratory to re-examine the evidence. They go for the technical lack of evidence in trying to disprove those claims, which means that you get more equity of arms insofar as those specific tools are what you disarm. This is important because the opening opposition principle is only true insofar as equity of arms exists a priori. But given that it doesn't, given that we talk about people who are already victimized by the wider society, but also face overwhelming odds in court because they cannot prove their case, the abuse of power will happen unless we rectify the inequity a priori, which is why the entire principle run by Ron, although it sounds good, is generic and doesn't stand in this debate. But I will give Ron a chance to respond to me. Yes.
Sure. You somehow narrow this exclusively, you say instances of ethnic discrimination don't matter into this debate, but somehow claim that this is about sexual assault. Do you really believe that no ethnic minority has ever been falsely accused of sexual assault, or even why this would be worth overturning the entire foundational principles of justice for this one crime?
Look, Ron, no team in this debate can claim a perfect legal system. The case is that most often sexual assault is committed by rich, powerful white males who tend to get away with it. And those are the most likely to not be convicted. I'm not claiming with perfect convictions. I'm claiming with more justice for victims. That's called a nuanced comparative. Debate is not 0 or 100. Lastly, we say we get more reports of things like domestic abuse and sexual assault because the primary barrier to you reporting a crime is the fact that you think that you're not going to be believed. Insofar as we get a larger pool of not proven verdicts, victims think that they're going to be believed, and this creates a multiplier effect effect, where others are willing to speak up because you attenuate their fear, and then you get the multiplier effect like the Me Too movement, where a lot of people fall and their crimes are exposed. But also, lastly, this challenges the wider societal perception that these kinds of reports of crimes are just for revenge and stuff like this. If the court, which is an objective third party, says that the crime has probably actually been committed, it combats the perception that victims are vindictive and actually entrenches the perception that indeed are victims. We are the only team in this debate with a comparative. That should be enough for closing government to go through.
Thank you for that speech. I would now like to call upon the member of opposition.
I mean, they're not lazy, they're not stupid, and they will do their duty. They won't say someone is guilty, but I don't have enough evidence, even if they don't
Look,
believe.
jury.
Well, CO seems very confident for a team without any impact. If they think that hung juries are a problem because, you know, people don't want to get on with each other and like they just hate each other, etc., why isn't it that loud jurors are just going to have their way and the others are like, oh yeah, they think they're guilty, let's fuck it, we'll just agree with them and get on with it because it's important for us to save 5 to 6 weeks of our lives. If these are indeed incentives that jurors respond to, then why under their side will like people who are louder or people who are in the majority with specific biases not end up having their way, therefore having a fucked up verdict under their side? I think in a lot of ways, in those instances, not proven actually doesn't sound that bad because you wouldn't want biased jurors to be that way. But more importantly, if you're running biased jurors, note this, both the sides in this debate will have to like defend juries to a certain extent because we rely on juries to come to some form of a decision, whether it be guilty or not guilty, etc. What, however, I'm going to respond to properly from OO and CO is that comprehensive defense that they have with regards to, well, not really comprehensive, but they tried, with regards to like the fact that, you know, guilty beyond reasonable doubt, etc., is actually a good metric to things. We think it is a good metric to things so far as to when you talk about like punishments such as prison. So for example, when it comes to putting people away for prison, we think guilty beyond reasonable doubt is indeed a good metric of things. We, however, don't believe that when it comes to giving the victim some recognition and so on and so forth, this is a reasonable reasonable threshold. Why do we think this is the case? Because oftentimes when it comes to things like, first of all, I think it is important to assume in this particular case that judges and jurors, I think there are some countries where like judges are the system, juries are not the system. Judges and jurors generally try to do as best as they can to get one of their whatever verdict that they want. And I think CO to a certain extent agrees with that as well, according to their speech. In those instances, it is important to understand that there are differences between sexual assault cases where the defendant actually has a proven alibi, which means that they're actually not guilty beyond a reasonable doubt. In those instances, I don't believe any form of a bias will lead juries to believe that these individuals are guilty, which is to say that in those instances, or like all go towards a not proven verdict. I think there are instances where juries are able to differentiate between evidence that conclusively proves that someone is not guilty versus evidence that shows in a lot of ways that the crime may have occurred, but that is where it stops. The crime may have occurred, but we cannot prove beyond a reasonable doubt. In those instances, I think it is important to recognize the victim. I think they don't respond to layers of characterization coming in from tin, but I'm just going to add to that a bit to a certain extent. I think oftentimes when it comes to specifically sexual assault cases, but also this applies to like any case where there is a power dynamic imbalance and so on and so forth, it is important to note that a lot of evidence gathering is very difficult on either side. However, oftentimes lawyers end up proving very small things within these places. So for example, in sexual assault cases, lawyers may end up proving that this individual was indeed a creepy individual who has been seen and proven with witnesses to make creepy advances towards someone, which conclusively does not prove sexual assault, but does prove that there was some bit of an intent, there was some bit of a trend going on in those instances. what happens under their world is, regardless of all of those evidences piling up, you put in a not guilty verdict because you're required by law to put in a not guilty verdict because there's no one who has seen that act happen. That is just how a lot of the crimes in society happen in those instances. And I think it is important to recognize in those cases that the victim deserves some closure as opposed to anything else. The only response we get from CO to this is, oh, but the Me Too, because Me Too is like, stigmatized and there's like a witch hunt thing going on, they'll think that the justice system has been captured. I would like to believe the contrary, because oftentimes what hurts the Me Too movement or overall movements for sexual assault is the fact that we get so high not guilty verdicts coming in, especially in developing countries like India and Bangladesh, where not guilty verdict rates literally lie at 98%. The statistics do not lie in these particular instances, which is incredibly problematic given the fact that oftentimes these crimes are indeed real crimes where you can understand from the victim's testimony and so on and so forth, but oftentimes end up being the victim's testimony versus anything else, and there not being absolutely conclusive evidence in those instances. I think what this changes with regards to social perspective, with regards to Me Too movement is, number one, the justice system is actually more credible than a lot of like loudmouth woke people. I'm not saying they're loudmouth woke people, but loudmouth woke people, according to the conservative and moderates that feel that way, justice system is actually a better place for you to show the number of not proven verdicts coming in case of sexual assault cases. And note that this is something that OO and CO accept, by the way. In their world, if there are 100 not guilty verdicts, at least under our world, it's like a 50-50 not proven versus not guilty, or like a 70-30 split, whatever the split that is. We have certain not proven guilty verdicts out of not guilty verdicts as opposed to guilty verdicts. Because when sexual assault is proven beyond reasonable doubt, there is no coming back from that, because like there is an active incentive to prove guilty in those instances. It is important to note in those cases that we get the people to change their minds with regards to witch hunts and the Me Too movement just being about people trying to take down men, because not proven means that the jury thinks to a large extent that they may have committed that crime, which is able to then change public perception. Before I move on, I'll take opening opposition.
If insufficient evidence exists to render a guilty verdict in the written letter of the law, then the judge can advise a jury of this, and if they ignore the judge and vote guilty anyway, then an appeals trial is pretty much guaranteed. So if your winning claim, or you think it is a few witnesses said that this person was creepy, so they probably did it, I think this kind of proves our point that this is an inequitable application of justice. You can't point to some failures in the status quo to justify completely ripping up the entire foundation.
Again, we are actually not completely ripping up the entire foundation, right? We are essentially not like giving prison time to these individuals, but the jury, as I said, has every incentive to be reasonable about not proven verdicts, because in those instances, like let's do some basic math to show this. Beyond reasonable doubt is actually a 95% probability. If the jury thinks there's a 60% probability, they're actually not allowed to give a not guilty verdict, a guilty verdict, even though they believe that 6 out of 10 times the crime probably occurred. It's important to understand how big a threshold 95% is, especially with regards to crimes that have power imbalances, where the lawyer isn't armed, like the lawyer themselves are not good enough because you're just a poor person who cannot afford lawyers and so on and so forth. Lastly, briefly with regards to like the thing with regards to like racism, I think Tin has already responded to this, but furthermore, I think it's important to note that when it comes to like people of minority races, it is important to know that not proven can act as a bulwark against the fact that they're always like tilted towards guilty. If there is like a confusion in those cases, confusions can be broken down into not proven verdicts, which can actually act in favor of minorities. I'm very proud to do this.
I thank the speaker for that speech. I would like to now invite the closing off whip to finish this debate. Here.
Just admit that there's going to be stigma either way, but as opening government tells you, at least if they get a non-proven verdict, they can appeal against this public opinion, which is better than on your side of the house, where they, even if they're...
Okay, I understand.
That speech, that ends this debate. The judges will now deliberate. I do believe we have a breakout room that's been open for us. Could someone confirm?
Oh yeah, I see it, banging.
Ah, great. See you guys there.